protest messages of different kinds, including New York City, City Council, and many other large and small, but lots of large cities, saying we don't want the Patriot Act. And my own library, where I live in the summer, West Tisbury, Massachusetts, along with a lot of other public libraries, has adopted a resolution which requires that when people take out a book, as soon as they return it, the transaction is expunged from their records. The reason for that being that one of the provisions of the Patriot Act allows FBI agents to demand, not a subpoena that can be tested in court, but just to demand of a library, place of employment, a bookshop, or anything else, to know the reading habits, the meeting places, the friends of any citizen. And furthermore, makes it a crime for the person like the librarian who is asked to tattletale, makes it a crime for the librarian to tell the person whose record is sought. And I think a lot of people are troubled about that.
And that is indeed a power that reaches each and every one of us. And it applies not only to library records, but to any tangible thing held by anybody. Well, focusing specifically on the so-called enemy combatant cases, we of course have two categories of them. One involves American citizens who are being held in military brigs in this country. The other involves non-American citizens who were allegedly captured on the field of battle, but they're disputing that. The administration is taking the position that none of these individuals should be entitled to any judicial review whatsoever, yet the United States Supreme Court has agreed to hear a couple of these cases. Are you, against the government's strong opposition, were you surprised as a court expert that the Supreme Court agreed to hear these cases, and is that a hopeful sign for civil liberties?
It's a great mistake to predict what the Supreme Court is going to do, and I'm not going to fall into that because I really have no idea. But it was a surprise because they've agreed to hear one of the domestic citizen cases, and that's of a man named Hamdi, who was caught, I should say captured, seized on or near the battlefield somewhere in Afghanistan during the Afghan War. Now, what he was doing, we can't tell. And he had a very extremely rudimentary kind of review on habeas corpus, in which all the government had to do was to say we caught him in Afghanistan, and that was enough to a majority of the United States Court of Appeals for the Fourth Circuit. Somebody who's caught on or near the battlefield during a war, we don't worry about, you know, little niggling details like whether he was fighting or just happened to be strolling by. That's enough. The other case...
Or worse yet, captured by a bounty hunter for the money, right?
Yes. Might have been captured by the Northern Alliance, and we did pay money to the Northern Alliance for turning over people that we suspected of terrorism, or that they did, or they regarded as an enemy.
Or as an opportunity to get some money.
Or as an opportunity to get some money. Now, the other case, you spoke of two domestic enemy combatants being caught on or near the battlefield, but the other one was not.
No.
Jose Padilla was caught when he got off arrested when he got off a plane in Chicago O'Hare Airport. And the claim is, which Attorney General John Ashcroft made publicly in a television address, he said, we have caught a known terrorist, thereby convicting him before in any hearing. Of course, there's been no hearing. There's been no trial. He hasn't been able to see a lawyer. He's been detained now in solitary confinement for 20 months. Now, how would you like that? With no idea how long you're going to be, no opportunity to talk to anybody except your interrogators, and they were candid enough at one point to say, well, we don't want any Mr. Padilla to see his lawyer because that might interrupt the interrogation process, which depends on trust and dependence. Trust and dependence between the interrogator and the subject, which is a way of saying we want to overbear his will. I thought that was pretty candid.
I still get chills when I hear that, Tony. It sounds like something out of Soviet Russia. And you say you don't want to predict what the Supreme Court is going to do, but is it really conceivable that the United States Supreme Court could put a seal of approval under our Constitution to this complete black hole into which these people have been thrown without charge, without the right to access to counsel, although I gather the government is saying, well, by our grace, we may exercise some discretion to allow you to see your counsel.
They said that, but they haven't done it, at least in the Padilla case. They have not allowed counsel to wonderful lawyers, Donna Newman and Andrew Patel.
New York Law School graduates, I should add.
Oh, yes.
But is it conceivable to you?
Yes, it's conceivable. I'm sorry to spoil your day, but Yes, it's conceivable. I say it is for this reason. In World War II, when the Japanese Americans were locked behind barbed wire in Utah and the desert, the case went to the Supreme Court, Korematsu against the United States, and the Supreme Court said, we can't second guess what the military said. Now, in fact, what the military said was a bunch of trash and lies, as we've later learned. But the court said, oh, no, we can't look into that. We have to accept their word. And Justice Jackson, dissenting, warned the very thing that you're talking about. We should, if they're going to do it, let them do it without our getting into it. But for us to put our stamp of approval on this terrible thing is to give it much more weight and to have a much more devastating effect on our civil liberties. That is true.
Now, Fred Korematsu, I have to interject, also is one of the distinguished winners of the Roger Baldwin Medal of Liberty, and you're following in his footsteps. But in fairness, Tony, a lot has changed in American law since 1945. That was before we even had Brown versus Board of Education. So the U.S. Supreme Court had not robustly enforced the Due Process Clause, the Equal Protection Clause. Even the First Amendment was a pale shadow of what it is now. I'm not defending the Korematsu case by any stretch of the imagination, but to reach a similar conclusion today would require overturning decades of jurisprudence that did not exist then.
I think what you say is true. It's not just the court, but all of us are much more rights-oriented than we were certainly 50 years ago. That's Korematsu, almost, well, 49 years ago, or 75 or 100 years ago. The kind of thing that the Supreme Court approved during World War I, putting people in prison for 20 years for criticizing President Wilson's policy. Can't imagine anything that would be more protected. The central meaning of the First Amendment, Justice Brennan said, is the right to criticize the government. 20 years in prison for doing so. So we're much more rights-oriented. But I think you mustn't underestimate the temptation of judges to say, well, you know, there may be things we don't know. We're not experts on national security. We better let the executive branch worry about that. I mean, I certainly hope you're right, but I have an anchor to windward because I know there are far too many cases over the years, far too many, in which judges just shied away from anything that the government labeled national security.
Let me ask you this, again, not asking you to predict what will happen, but Chief Justice Rehnquist, who has been very supportive of government power in general, also has been a very eloquent and forceful advocate for judicial independence. And don't you think that one could appeal to that aspect of his philosophy in terms of rejecting the administration's claims of unilateral, non-judicially reviewable power? Isn't that something that even Chief Justice Rehnquist would be upset about?
I hope so. It's a good point, which was summarized in the headline over an article by my former colleague, Linda Greenhouse, and the headline was, "The Imperial Presidency Against the Imperial Judiciary." And this court, the Rehnquist court, has shown itself very sensitive to anybody muscling in on their territory. So let's hope that it continues.
That might be a strategy. Now, I wanted to ask you about the other group. This was the group that I said had allegedly been captured on the battlefield, and that was those who were being held in Guantanamo, which a British law lord, and apparently very unusual thing to do to make a public statement, referred to as a legal black hole. And we've had many unusual developments there, unusual briefs. You were telling me about one beforehand that you might want to mention to our television audience.
The brief of the parliamentarians?
Well, and also the...
the brief of the lawyers. Yes, that's an extraordinary thing. President Bush, shortly after 9/11, issued an executive order laying down the rules for military tribunals to try any alien suspected of terrorism or harboring terrorists.